Vampires go to law school, damn it.
No thanks.
That was the nicest thing anyone's ever written about me.
Oh, at surgery, got a titanium rod. I'm getting caught up though. I'm getting.
It's
more
the nicest
done
thing anyone's ever written
than
about me.
are
Thank you.
accruing. That's my
You
goal.
bet.
Yeah, one set of minutes
By far.
when I broke my leg.
Oh, yeah.
Crashed my bike.
Congress has repealed the law of averages. And gravity.
Should I just retire from exercise?
And the law of diminishing returns is on the Ways and Means Committee agenda for today.
It works really
Hi, John and Barb.
Steven's not here. He's on the phone. You will not bring something. All right.
He's got a chair on the phone?
I haven't
I'll
talked
have
to
a heart
Jeremy.
attack though.
It's gonna be.
Cricket's coming. I was hoping Jeremy.
Got
I'll
everything.
try and get to it as soon as I can. So what's your deadline again?
I did.
Hey, who's cricket?
All right. I'll try to get it.
Where's the cowboy hat? Barely recognize you.
Want me to go get it on if you
No, it's all right.
I'll get something.
Not threatened, just confused.
It's
It's like I said, it's so early in the process, it's hard to answer
You're not old enough to know this.
definitively a lot of these questions because I don't.
I'm pretty old.
She knows.
All right, I'll get some.
Get yourself an
The Smothers Brothers.
Oh, I know who they are, but I haven't heard
You
that.
do know who they are?
Oh, hell yeah. I am old. I really am. I'm old. Admit it. Come on. Back me up. Thank you. See, he backs me up. Yes.
Thinking you're old does not demonstrate that we like
He agreed. That means he likes
Okay.
it. So give me that.
you. All right, I'll give you that. You know, you're still a big girl.
I do. Compared to everybody else. Well, I'm glad. Especially.
How you feeling, bud?
Okay. I spent the morning working on my shop out in the sun on heat stroke.
I saw your cheese deal.
Oh, that's not what heat stroke.
How big is that? This?
It's like that.
Oh, I couldn't tell in the picture. It flew fast and
Well, it is noon. We've got a quorum.
Yep, we're ready.
is Stephen on there?
Yeah, Steven's on.
Okay, you tell me, I have things to record back.
Hi, Steve.
We're ready.
Where do you
We're
want?
ready.
Jeremy's going to try to make it.
Okay. Welcome, everybody. Today is September 6th, 2019. It's 12 o'clock noon. We are convening the Grand County Change in Form of Government Study Committee regular meeting. The members of the committee that are present: Judy Carmichael, myself, Marcy Till. I'm acting as chair. Stephen Stocks is on the phone in Texas. Bob Greenberg, Cricket Green, and Walt Dabney are here. Also here, Chris Baird, County Clerk, Ruth Dillard.
Dylan.
Sorry, Dylan, my bad. And Gavin Anderson, our attorney. Yes?
To make this legal, I would like to make a motion that we elect Marcy Till as chairman pro tem for this meeting.
Oh.
Otherwise, you
Well,
ain't
we
chair.
don't have a vice chair, so I think that's fine.
I second it.
Oh, I guess I call for the vote. Okay. All in favor? Great.
Have fun, Marcy.
I've never done this before,
You
so.
really have
So-
to too, Marcy.
Mhm.
Madam Chair, you have a vote on the phone too,
Oh,
and you want to call the vote.
Oh, I want to call for the vote? Okay. You guys just guide me. Stephen, how would you like to vote?
And so what was that?
Okay, so that's a unanimous vote.
Of,
You have to say, it
One,
passes.
2, 3,
It passes.
It passes unanimously with
That's all you have
6
to
votes.
say.
Oh, thank you.
Sex. Oh, yeah, Jeremy's not here. Is
He's
he
on his
okay?
way.
He's on his way.
Good.
I talked to him. They had a fire.
Cricket, would you like to lead the Pledge of Allegiance?
Oh,
First,
love
first sewage, then fire.
pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Next item on the agenda is approval of the minutes. Does anybody have any corrections or additions that they would like to make to the minutes?
And Madam Chair, may I? On your dais is one that says item A, replacement, and that is because if you flip over to the page 3, you'll see in the left margin, that is what I intended to be in the minutes. Oh, look who's here. Welcome, Jeremy.
Okay.
So I had it in there twice in 2 different ways. Anyway, that is the one that I intended. So when you're voting on the minutes, vote on the ones that are in front of you on the dais.
Okay.
Madam Chairman?
Yes.
I would like to make a motion that we approve the replacement minutes.
Do I have a second? Cricket, seconded. All those in favor?
Do you have the vote,
Stephen, do you have a vote to approve the minutes?
Aye.
Okay, that passes unanimously with 7. I'd like to note that committee member Jeremy Day is now present with us.
Slowly,
Slowly but
Welcome.
surely.
we're here.
We're glad. Okay.
Proof.
The minutes,
Alive and well.
the minutes are approved. We're moving on to general reports. We have a review from our county attorney as to compliancy of the draft optional plan with the state constitution. And I would like to invite committee members to respond or discuss. Mr. Greenberg?
May I pass Stephen around? I'm afraid he won't be able to hear.
That's just the weirdest thing I've heard today.
Hi, Steve. Hi, Steve.
We're working on our system, but it's not.
Okay, let us know if you can't hear.
Okay, I will.
Okay.
I read the county attorney's report. I know that many of us will be disappointed that there are some items to fix, and thus it will not make the ballot this year. Luckily, I think the items to fix are pretty trivial, and we can fix them quite easily. And I suggest that we look forward to doing that at a time that the county attorney can be here with us, so we can get her indication of whether or not the language we're proposing will in fact fix the issues that she's found. And as I don't know if everybody knows this, but she's up in Salt Lake with her husband, who's having major surgery at 1 o'clock today. So I don't know. At Jeremy and then Chrissy, it's a dangerous committee to be associated with.
Any other comments or discussion from committee members? Well,
Yeah, with Gavin here, are we going to go through this? I'd like to go through this and part by part, see who's got comments or questions. I do. I think I understand it. I've read it several times now. Most of it, as Bob said, is pretty small. I mean, if we said you need to have an election on a certain date and we weren't supposed to say that, I mean, that's fixed now because we can't make that date. But there's a couple of things in here I think that are more substantive that I'd like to have a discussion on. And so I can either start that now or however you want to do it.
I was
Chair.
just kind of starting with general feelings, and we can go through this item by item.
I would prefer that. That's how we did it.
I would too.
Yes, Mr. Stocks?
At this point, I would like to make a motion to table this and return to it later in the discussion. The basis for that is I think there's a lot of questions that we have that may or may not be best approach in the current method, but I would suggest perhaps going through all the other items and just reapproaching this at the end of today's topic. So I would make a motion to table the matter for the general report and the review of her report.
I'll second that.
Okay, we have a second from Mr. Greenberg.
I was trying. Second.
We'll let you.
All
was
those in
second.
Question.
favor?
Wait.
We
So
have a
discussion.
We
discussion.
have a discussion.
Okay,
See, G, and Gavin's, I assume this is yours, Gavin, this item G, corrections to optional plan draft.
Yes, that's correct. It's in
Yeah.
your packets as item G. Yes, you
Yeah,
got it.
that's going to be the most helpful thing to discuss, really. Other than disappointment, I don't know that our feelings about the county attorney's report are germane here. What's germane is fixing the plan so that she will approve it, so it can go to the voters. Really, no one but the county attorney has statutory responsibility of reviewing it in this manner, and there's no provision for overturning her recommendations. If she were present, we could certainly discuss and argue with her, but nonetheless, there's no provision for her changing her report either. What we got is what we got.
Can I make a point, Madam Chair? I agree with Bob, and also to the extent, Mr. Greenberg, to the extent that though this might be helpful, item G might be helpful, it is my suggested corrections, we really have to sit down with Ms. Sloan and go over these items and make sure that it would pass her review again. The suggestions that I've already made.
can I ask a question?
Microphone.
Can I ask a question that is maybe, it's obviously a moot point at this moment in time? But if we had made corrections today and the county attorney had looked at them and reviewed them today, would we still have met the deadline?
No.
I think it would have to be by close of business today, and it'd have to include Ms. Sloan's review by the close of business today. I think that's probably impossible with her situation.
Gavin, what about the prohibition against changing the plan for 120 days prior to the election?
That's a good point. I'd forgotten that. Yeah, that pretty well alleviates anything we could do today. Good
Okay.
point.
Madam Chair, just a reminder, you still have a motion.
So we have a motion on the floor to table this item
Until-
Just still discussion.
later. Jeremy?
I would just like some clarification on what Bob said. So you're telling me Christina is the wherewithal final point of contact, whether this is it or not. So you're telling me that a county attorney, an elected official, is the point of contact and the final say on whether or not our work goes forward. Is that legal?
Is that a question for me?
Sure.
Yes,
Yeah.
yes. The statute's fairly clear, HB 224, and in fact, it's also the same law that was in the predecessor to HB 224, that once the plan is done, the county attorney gets to make legal review of the draft plan, the optional plan, and determine whether any of the provisions in that plan are either contrary to state statute or contrary to the state constitution. If so, then the county attorney is obliged to mention exactly what the provisions in the plan are, exactly what the problems are, and I believe also a requirement that she make suggestions for changes. I think Christina's done a good job of doing all those. The next part in the statute is there's no review, there's no way to appeal her decision, other than, I guess, you could always take it to court. The timeliness of that enterprise would be questionable. And then it starts the clock running again for the optional plan to be revised using the county attorney's input, and a second amended optional plan submitted again for review by the county attorney, and then the amended plan, if it meets legal muster, could go forward to the voters at that point.
Thank you.
Mr. Greenberg?
I'd just like to remind us all that it was something of a miracle that we were able to submit a plan with any hope whatsoever of getting on this year's ballot. I mean, it took extraordinary effort on this committee's part. So
I agree, Bob.
I guess the miracle didn't quite occur.
I just wonder if that extraordinary effort was given back to us at this point.
I don't know what you mean.
Yes, Stephen?
A question for Mr. Anderson. The review from the county attorney is merely to tell us whether or not we run afoul constitutionally. In my reading and understanding, it is not her position to tell us what particular things to do. For example, the setting committee, she is essentially directing us to give the districting issue back to the county council. I think that's going above and beyond what her statutory duty would be, and venturing around with what Mr. Anderson, your position would be. Am I misunderstanding that?
I've got the bill in front of me. Let me do a little bit of looking, Mr. Stocks, and I'll respond to that in a moment. I don't recall exactly what the county attorney's responsibility is going forward, but let me get back to you in a minute or two.
Well, I might be able to answer that if you want. I have it
Chris?
right in front of me.
Louder, Chris.
So the 1752A 501, what triggers an election is this first provision. If the county or district attorney finds that a proposed optional plan does not violate a statutory or constitutional provision under 1752A 406, then it proceeds to election. So there is no provision that says it goes to election if it does. And so, the only way that I can put it on the ballot is if it does not violate statutory or constitutional provisions.
Mr. Greenberg?
And as I read it, Steve, the county attorney's report calls out that we kind of usurped the legislative body's authority in calling out in detail what the districts should be. So it wasn't really a suggestion we give it back to the council. It's a recitation of the law that gives that authority to the state legislature and then delegated by them to the county council. So there's no other, in her view at least, which is at this point the final word, there's no other way to do it.
I agree with Chris in terms of the election not going forward. In section 406, it talks about how we...
It's on the dais.
Yeah, it's should be in your package. Item G. States the process for the county attorney to review and prepare a written report. State the attorney's opinion as to whether implementation of the plan would result in a violation of statute or constitution. Identify the statute or constitutional provisions. Identify the provisions of the plan that are affected, and recommend how the proposed plan may be modified. And then if there is a violation, there's no election, but the study commission can fix the initial plan and file a new report. So not only a new optional plan, but a new report. We might call it an amended optional plan, and then submit that modified plan again to the county clerk.
I just want to make the comment about HB 224 in that the county attorney is specifically not involved in the creation of this document, and yet in the final analysis they're absolutely completely responsible for whether or not it moves forward, and that to me seems like a contradiction.
HB 224 is riddled with
I know.
bad
I just want to. I
law.
want to point that out. The other thing that I think is a little worrisome to me, and that is, and I don't know how closely. First of all, I want to commend the county attorney for her eye to detail and her, scrupulous examination of our plan. It's clear she gave it a lot of attention and a lot of thought, and found some mistakes that are easily correctable, like in about 6 sentences. And I don't know how we get this information back to the legislatures about how faulty the bill is, but the other thing that occurs to me as the county attorney is kind of witnessing our process. Clearly things are occurring to that person about what might or might not be constitutional, and if we had had some routine input along the way even, I think we might have avoided this. And that's just my personal opinion.
Yeah, I think the reason the county attorney is independent review is to maintain some separation of powers. And to have, as she said at the beginning of the process, she can't be our attorney because then she has to review it, and that needs to be completely separate.
Well, she can't be our attorney either because she's
Right.
their attorney, the council's attorney.
And the county's attorney.
Yeah.
Right. And
We're
we're an
supposed to be
independent
That's right.
body.
So we have
So
a
I think
motion
it's,
on the floor to table this, and we have a second. Is everybody ready to vote? All right, all those in favor?
Aye.
Aye. Passes unanimously, 7-0. Moving on to community outreach and possible action.
Never mind.
Yes.
I think probably the argument in
Yes.
favor is still going to be good.
I think this is another one we can postpone. I don't see the purpose of setting up dates to brief the public when we're obviously not going to be within a year of a election.
So wait, we're on item C, approving the opposed argument in favor statement.
Oh, I thought you said,
No, we're on item C right now.
okay.
I'll make a motion to approve.
I haven't even looked at it, but that's.
Me neither, but I
It's
trust Walt and
brilliant.
Steve.
It's brilliant. Do we have a second? I'll second. Okay, any discussion on that item?
What was the motion? I'm sorry, I didn't hear
The
it.
motion is to approve the argument in favor of the draft optional plan.
But isn't this redundant?
I think,
Yeah, it's a little.
Open discussion.
Yes.
It is wonderful, but it depends on what we do with the final outcome with the suggestions from Ms. Malone's office. So at this point, I don't believe that we should approve it because it doesn't, it matches with what we currently have now, but one of the biggest parts, or probably the whole largest parts about County Attorney Cologne's review is the district. And so with that being something that is up in the air, so I don't think we can approve it.
I agree.
Any other discussion?
I'll agree with that, with Stephen's sentiment.
Yeah, me too.
It makes it mute at this
Okay.
point because as wonderful as it was, it literally makes it, going back to some of the drawing board, and we don't know what that's going to look like when it's said and done. So we need to get to the drawing board again before we put out a in favor of, yeah. I mean,
Okay.
yeah, we're all in favor of what we did. But now we need to have some discussion of what happens going forward.
Well,
Yeah, I don't see anything in any of her recommendations that's going to change what we did, nor the value of what we just did with the pro statement, but I'm perfectly good with waiting on it till we see. She's not suggesting that we need to change what we recommended. She's suggesting that we made some errors, some of which we'd like to talk about a little bit.
Okay. I'll call for the vote. So all those in favor of approving the argument in favor statement for voter information pamphlet?
Again.
Those in favor? Those against?
Nay.
Nay.
Bob would like to point out that he's voting against himself again.
That fails, 0 to 7. every member of the committee voting against it.
Madam Chair, would you
Yes.
want to postpone that item indefinitely?
Um,
Well, it just died,
Yeah,
Yeah.
that's right.
so
Yeah.
it doesn't need
So
to
it'll
be
just come back
postponed.
on when it does.
Bring
Okay,
it up
that's right.
Bob will resubmit it.
No,
um,
Stephen Walt will rewrite it.
Right.
let's, moving on to item D, developing a new campaign to educate the public on the status and contents of the draft optional plan. Walt?
That's what I thought we were on a while ago, and I don't see any point in doing that right now till we have fixed this and have the concurrence on the county attorney that we're ready to roll, and then do that in preparation for hopefully 2020 election.
Do you want to make a motion to that effect? Mr. Greenberg?
I think we should anticipate at least one public meeting to explain what happened and where we're going. Although I'm sure the newspaper will cover it.
Let's let him be the public meeting.
Yeah, okay. Well, certainly, once we've revised and the county attorney has reviewed it, then we need to have at least one public meeting at that point, it seems to me. Even though it won't be in the lead up to the election, but at least it'll kind of close out our work and present to the public what it finally turns out to be.
So,
The way
do we
D
want to postpone this then?
the way D reads though is it's compliant in time for the 2019 general election.
Yep.
If we want to amend it, we can. But
Well, it says whether or not.
whether or not.
That was what you all wanted.
Yeah, I don't know that we need to take action here.
Marcy,
Okay.
can
I
I,
think
can I
we're-
say something, Marcy?
Table
I
it.
think we can table it, postpone it.
Madam Chair. I think the original intent of public hearings in HB 224 was to hold them prior to making a final decision on what you're submitting to me. That's the way I read it. And if you read the actual timeline, it's established such that you hold your public hearings, get feedback, and then if you're going to make amendments based on the feedback you get, I mean, you've already kind of done a lot of that, but that's just what I'm saying. You know, it's not necessarily that it's just educational meetings. You now have the time to hold public hearings if you want.
Yeah, we understood that, Chris, and we've been over backwards to have a very open and inclusive process, and I think we did that very well. We knew this was optional, but the group, in the same spirit of public interaction, wanted to go back out, actually add a little work to our load to go back out and make sure everybody understood that we listened to them, and this is what we came up with.
Well, I
All
understand.
we're saying is, I still think we ought to do that down the line, and we need to do that at a reasonable time before the next election. It's not for the purpose of changing what we did, because we can't do that.
You can now.
Is it necessary? No. Is it a courtesy?
Yes.
Absolutely.
That's exactly what.
And I think we all
Yeah.
agree.
Yes. I agree.
So, well, I guess what I'm saying is you did not hold a public hearing on your finished product.
No.
Right.
And we're not
That-
talking about a hearing per se. We're talking
But
about
you can, that's what I'm telling
Right.
you.
Yeah.
And just a reminder that your work is done early March, so it wouldn't be too close to the next year's election.
Right.
So I make a motion to table this.
As in postpone it.
Postpone? Yeah.
No, let's table it.
We'll
What's
table
the
it to the end of the
difference?
meeting, or?
Postpone it.
Postpone.
You want me to postpone it? Okay, let's postpone it. Do I have a second for that?
I'll second it.
Concept? Jeremy Day seconds.
Get my second.
Is there further discussion on
we owe you some
postponing the education campaign to the public? If not, I call for the vote. How many would be in favor of postponing? Stephen?
Aye.
Aye. That passes unanimously, 7-0. Moving on to item E, suggestions for additional public service announcements. I believe that this kind of falls into line with item D. I, however, have a budget question for our county clerk, and that is, if we line out an advertising / public announcement campaign for October 2020, if we get it to the advertiser by March, or wherever we're going to do it, the newspapers, if we get it to them by March, complete with our information, and we
get a
have a
big
budget for
discount for getting it in
advertising,
early.
would that be legitimate?
It would be like the last thing we did as a committee.
You mean like in relation to your 1 year?
Yes.
Is that 1 year?
In relation to our 1 year, we have to stop ceasing to act as a committee in a year, but we do have a budget for public information and advertising, and since officially we can't act after March.
Is that really what the statute says?
Yep.
Yes.
So it says that I know that it says you have to have your plan done by then.
1 year from the first meeting.
I know you
We
guys don't
dissolve.
want to.
I think it
No,
says,
it's
says we
really
dissolve.
clear. This body
Doesn't it
has
say
a year.
dissolve? Didn't-
Dissolved
I mean,
in
I
a
don't
year.
even
Says
think
dissolve.
that the
already
announcements need
slowly
to be
dissolving.
tagged with study
Just our
committee
spines.
I think that's a good
identification,
idea, Marcy.
but-
No, we'll figure out how to advertise for it.
It's a
if
good
you
idea.
want.
And we'll get a big discount for getting it in so early.
Yes, we will. So, any other suggestions for public service announcements other than I think they need to dovetail with what we ultimately decide to do about our open house cricket?
I make a motion, we postpone this till we have a plan.
Second.
Any other discussion? Okay, all those in favor postponing?
Aye.
Aye. Stephen? Aye. Okay, that passes 7-0 unanimously.
Wow, we all
Hey! How come there's no citizens to be heard on here?
Oops. Just throwing in.
Goodness, I
Let's
made
put it
a
on
mistake.
presentations.
Yeah.
Yeah, that could be our
I
presentation.
apologize.
Ruth, that's impossible.
I know.
No,
Right?
no. I'm not going to believe that.
Me neither.
Can we?
Chair?
It was I don't know what happened. I apologize.
Can we amend the agenda?
I think we should, because it's a standing agenda item.
I'll make a motion to amend the agenda to have citizens to be heard at the same time of presentations.
Second.
Any discussion?
Yes.
Walt?
Would it make more sense to have citizens heard before we have the discussion of this thing or after? I kind of think it might make more sense after, but
Any other thoughts?
Yes, citizens can speak to any agenda item. The citizens to be heard is for items that are not on the agenda. So, there's other opportunities to speak.
Okay, so we have a motion on the floor to add citizens to be heard to presentations, and it's been seconded. If there's no more discussion, all those in favor?
Aye.
That passes unanimously 7-0. As there are no presentations, I would invite any citizens to be heard to step forward if they like.
They just don't want to say it.
Okay, come on up, Charlotte. And please state your name. Come up to the microphone here and do state your name.
My name is Charlotte Mates, and I'm a citizen of Grand County for the last 20 years and 4 years prior in the 50s. And I do believe that this committee deserves to be commended tremendously. I don't understand all the ins and outs of why this cannot go forward on this election year. I believe that it should be imperative that it do that. And I believe that sometimes in law, you have to look at the circumstances, and you have to look at the overall general results of a situation like this. And in my own humble personal opinion, I believe this should be on the 2019 ballot as of today, being the deadline. Whether our county attorney is able to be here or not, because of her personal reasons, should have left someone else in charge of being at this meeting as her representative to make a decision, have the discussion with this committee, and be present and accounted for as a county. This came from the state level of our legislature. I believe that if we delay this, and I, again, am not current on all the legal ramifications, so those of you, Gavin and Stephen, who do understand this better, or anyone else on the committee who understands it better, can put in your 2 cents and have a discussion on it. But I firmly believe this needs to be on the 2019 ballot. It needs to be voted on by our citizens, and it needs to be implemented immediately. Whatever the outcome is, let the citizens talk, and let the law of the land take its course, and not have any of these little idiosyncrasies that are going to prevent the reputation of this county and of the hard work of the 7, and I include the other 3 that are not actually the study committee. The members of this committee who have worked diligently, repeatedly, and conscientiously to make this happen in our county should be applauded above and beyond the law. And I'll go on record as saying any one of those. Thank you for your time and attention.
Thank you so much. Thank you. Couldn't agree more.
Are there any other citizens to be heard? If not, we will move forward with our agenda. General business, action items, discussion and consideration, there are none. Consent agenda, there is none. Item F, discussion on the study committee's role for the transition plan if the optional plan is on the 2019 ballot and voted down. This seems like a moot point at this moment in time, and I don't know what we do about that.
Just move on, I think. Yep.
Okay. Item G, discussion and possible action on study strategy. Next steps if required by the county attorney. And I believe I would like to, at this point, go through, I would like Mr. Anderson to kind of walk us through Ms. Sloan's letter and issues to the committee and his suggestions for corrections. And I think that we should go through this piece by piece like we did the optional plan, so that the public clearly understands what the issues were or are with our optional plan.
I would like to clearly understand.
Okay.
Myself.
Madam Chair.
Yes.
So are you taking off the table item B, the review of the report, and kind of combining it with item G, the
Yes.
corrections? So
Can we
maybe
do that?
maybe for the record, if you would read those 2 agenda items.
So we are actually combining item D, item
B.
B, review of county attorney report as to compliancy of the draft optional plan with the state constitution and state code. And we are combining that with item G, next steps, if required by the county attorney for correcting the draft optional plan for compliancy with the state constitution and state code. And
Madam Chairperson,
yes, Stephen?
could I make an odd request of Mr. Anderson if he could go through the document in reverse? to handle the smaller issues and then approach the larger issues of districting?
What a coincidence. I was going to suggest exactly the same thing.
Okay. So, Mr. Anderson, if you want to lead us through this, will you reference Ms. Sloan's concern
Mhm.
and then the correction
Sure.
that we're making or would feel is appropriate?
And if you'd like to discuss the corrections hand in glove with Christina's letter, that might be helpful.
Yes, that's what we would like to do.
Okay.
Madam Chairperson, could phone be passed to Mr. Anderson?
Yes, indeed. Here he comes.
Oh, it's such an oddity. I love it.
It's like a spaceship.
I feel special.
Sure, but I'm good. I just need to stand. I can't sit for very long or stand for very long, or
You do whatever you need to do. Sit-ups, push-ups. Just lay on
I
the
wish.
I hate to mention to Jeremy about back surgery, so I won't.
Can we get
You know,
Gavin a
yeah.
microphone?
Is it not coming up?
No.
That mic's always had a little bit of issue.
Is that better? Yeah, that's better. I can hear. All right. On Ms. Sloan's page 9, item 4, removal of officers. I have to confess that this was just a dumb mistake on my part. But that said, I think it's the closest thing to a direct contradiction in state law. Let me just explain what went on there. As you're aware, one of the issues with the Grand County and the Morgan County plans of government is the permissible removal from office of elected officials by a removal election. So HB 224 says you cannot do that anymore, and you have to remove it from the plan. If I'd been smart, I would have just left it completely silent in the plan because it already says that in the statute. But I thought kind of a belt and suspenders approach to this, and to mention it in the optional plan. 20/20 hindsight, it probably would have been better not to. The other thing I overdid was to mention specifically the judicial removal process. And Christina mentioned that there is a statute on the books in the election code that permits the removal, involuntary removal of an elected official for mental disability. Christina and I have had a lengthy discussion about this issue, and my position is the statute regarding removal for mental disability is not constitutional. And I've made that argument in other settings before. The state constitution says, first of all, it's got a section that lists officers, elected officials who are liable for impeachment. And that is only the governor, the attorney general, lieutenant governor, state auditor. And it says all other officials may be removed for high crimes, misdemeanors, malfeasance in office. So for cause. And because it's high crimes, misdemeanors, malfeasance in office, to make that determination is of necessity a judicial process. And then later it says any other elected official, still talking about the state constitution, any other elected official may be removed for any purpose set out in this article, meaning in the state constitution. And again, the state constitution only mentions 3 things: high crimes, misdemeanors, malfeasance in office. So the state statute she referred to in the election code adds removal for mental disability. It's a strange statute. It only talks about mental disability. It doesn't talk about any other disabilities. I think it's clearly unconstitutional, but it is undoubtedly contradictory to existing state statute, though I think it's unimportant, which is another thing I tried to convince her, because the statute, the supposedly conflicting statute is unconstitutional itself. So there's that. The proposal to cure that plan, or cure that problem in the plan, is on page 3 of the corrections. It's item G in your packets. Page 3, last line. We changed the sentence that currently reads, officers and members of the council are not subject to term limitations and may not be recalled or removed from office except by the judicial removal process set out in state law. It's a simple enough matter to just remove the word judicial and say cannot be recalled or removed from office except by the removal process set out in state law. Questions, comments?
Where are you reading that, Gavin?
Right here.
So we're going backwards, Walt. You're on that third page.
We're between two documents now.
Yep.
He's just looking. He's looking at, accidentally, there's 2 G's in our packet. So,
Oh, I was looking at the wrong G.
yeah, you're looking at the wrong G.
Yeah, okay.
They go,
So that's clearly easy to fix, and in fact, that's what she recommends we do as well.
Striking judicial.
One word.
That one I think is very simple. Again, I apologize. That was a mistake on my part, and like we've said, easily removable. Going back again to Ms. Sloan's review, the third point.
Mr. Anderson, before you move on to the next item,
Yeah.
let me just ask you, just with your understanding of the optional plan, would that clause in and of itself trigger it being unconstitutional, or does the language with having judiciary be in there, is that it's language that applies essentially don't break the law, but adds that language in? I mean, one could read a lot of things into it, but it in and of itself, that triggers something that would make this optional plan unconstitutional. Just that element alone.
It would certainly not make the optional plan unconstitutional. Ms. Sloan's point was that it makes it contradictory with existing state statute, which is one of her charges, is to find those kinds of problems as well. And it is clearly contradictory to a state statute. As I mentioned, I don't think that state statute is a constitutional statute.
Has it ever been tested in court?
No, it's only about a year old, maybe 2 years old. And to my own personal embarrassment, it comes out of Salt Lake County. It was the issue that we had with our elected county recorder a couple of years ago.
Remember.
Thank you.
Other questions, comments? Ms. Sloan's third point is about the election date, setting a special election. Page 7. The corrections, page 2. This point, I think, is a bit of a misunderstanding and a misreading of the language of the optional plan. And it also calls into question, I think, the county clerk's authority. I know in this matter the county clerk had asked for advice and opinion from the Lieutenant Governor's office. I can turn this over to Chris in a minute. But her suggestion is that the optional plan attempts to establish the election day as this November 5th in 2019. She says that's improper for the study committee to do that because that authority is vested by statute in the county governing body and has some fairly significant procedural and limitations tied to it. My concern is the actual language of the optional plan, which is in the attachment G document, bottom of page 2. And again, this is a matter of discussion with Ms. Sloan. The language literally doesn't establish the election date. It only makes reference to the election date. And the election date would be established by the operation of law as set out in HB 224. The cure is very simple, just to eliminate a date. We need to do that anyway. I think it's a matter of convenience to have the adoption date in the optional plan. Salt Lake County changed its plan way back in 2000. I just had somebody ask me just the other day, now did they do that in 98 or 2000? It's kind of handy to be able to open the optional plan and find out when we really did vote on it. So I think having the date in the plan is both a good idea and relatively harmless. But Christina's made the analysis based on who gets to set a special election date. Mr. Baird, do you have?
Gavin?
Yes.
This is a bit of a sore point with me in particular as the plaintiff in an action against Grand County a number of years ago when the county clerk proposed unilaterally to place an item on a election ballot without the county council calling a special election. And the district court found in that matter, found in favor of the plaintiff and required that the matter be removed from the ballot unless and until the county council called a special election on that matter. And Chris and I have discussed this, and I think kind of there's a lot of wiggle room here, but nonetheless, that's what the district court said in this district.
Yeah, and I have no doubt that that would apply to any number of situations where there was a special election desired or advanced by individuals, electorate, or whatever. But this really doesn't apply to a situation where someone is coming before the county and saying, we want to have a special election on such and such a day, in which case I think clearly that judicial decision would apply. And as I mentioned, there are specific requirements and procedures to follow to set a special election date. My point was that in this setting, the special election day wasn't set as a special election day. It was set by operation of law in HB 224.
And so if we take that out, Gavin, for this time, and there is a general election scheduled for November of 2020, and we reference that, would we be in violation again?
We'd have to talk to Ms. Sloan about that.
We're not setting the election date.
Oh, I understand. Yeah. We are just acknowledging that that was the day that the people voted. It's other comments, questions?
Well,
Mr. Anderson, if I may.
Yep. Stephen?
You stated that this is just a matter of convenience. In your legal opinion, this does not establish the election date, just references to it, and it's a relatively harmless area. Is that my understanding on it?
That's my position, I think. Let me just read the language from the existing optional plan. This plan shall be considered adopted, so it's setting up this notion of being adopted as of a specific date. This plan shall be considered adopted when approved by the affirmative vote of the majority of those voting on the question of its approval at an election to be held in Grand County on November 5th, 2019. So it doesn't actually set the election date, it only acknowledges it.
Thank you.
So do we want to take it out, or do we want to just change it to the 2020 date?
We have to ask Christina what she'll sign off on.
Right, so that's a...
This is an opinion. This is much ado about nothing.
There's been a lot of that.
We've split more than one hair here.
We see on page 2 of the corrections, we see Mr. Anderson's suggestion of just removing the date and ending the sentence with approval at an election to be held in Grand County, period.
I'd like to hear what Chris has to say, if that's okay, Madam Chair.
So, I mean, this is what HB 224 says, and it doesn't actually specify that it's a special election, which is, so it confuses me why Ms. Sloan considers it a special election when it's not considered one in the law. But she is right in that here's what the law says. It says when the conditions described in subsection 1 are met, And that has to do with her providing a favorable report with no violations, not less than 60 days before an election. It shall go on that ballot, the next ballot. So, if she had returned a favorable report with no violations, not less than 60 days, then it would go on this year's ballot. And so it really is triggered by the point in time when the conditions in 1752 A501 are met. And so, but it doesn't really mention it being a special election. It just says a county shall hold an election on the optional plan of the next regular general or municipal general election that is not less than 60 days after the submission of this a favorable report. And so I guess it's really the conditions that dictate it, and I don't know that I'd necessarily even call it a special election per Title 20A. And the lieutenant governor, kind of backed me up on that, I think. And so, but it's a moot point, really. I think at this point, when we rewrite it, we just leave the date out. And if she comes back with a favorable report the second time, it'll run in the next election, and that's just the mechanics of the law.
And that's what I mean by the concept that it's not an election that's set by the county governing body. The county governing body would not be permitted to say, no, we're not going to have the election, assuming that we've gone through the process completely and correctly and there'd been a favorable report from the county attorney. Then the county governing body would have no role in setting that as a special election day. That, Bob, I think is the difference from the litigation you're describing.
Well, the law says shall, and it requires me, the county, and the legislative body to do it. If all the circumstances are there is no option.
Thank you.
Any other questions or comments? Okay, Mr. Anderson, moving backwards.
I think there's lots. Keep my mouth shut.
Just a kind of a caveat, I don't feel completely comfortable shooting holes in Ms. Sloan's review without her to defend herself. So let me just admonish the committee. One of the first things you learn in the law is there's always two sides to every story. Sometimes there's 3 or 4 sides. And so I hope you would not take my characterization of the county attorney's position as being what her position is, other than what you've got in writing in her opinion.
Gracious to the end.
Yes.
Well, and the only individual who gets to decide whether an attorney's interpretation is correct is a judge, in fact.
Well, in this case, it's the attorney herself.
Well,
I'm sorry, Mr. Stocks.
Okay.
And I can clarify, the questions that I'm asking you is for your legal advice, and that's why and that's why you're our attorney. So I take it, separating this person from the argument, I understand everybody has an opportunity to defend themselves. I agree completely with that. But I'm looking realistically at what items have merit and what items, perhaps don't. So that's what I'm gauging my questions at, and that's kind of what I'm trying to hone in on, because none of us are experts in this particular area of law besides yourself. And so that's why I'm asking the questions to you. So I'm not trying to pit you against her. I'm just trying to get your grasp on it. You're going for it.
Oh, I understand that completely, and I do recognize that as part of my role in providing legal advice to the committee. It's just that we would maybe have a little bit better analysis, if it were possible, for Ms. Sloan to be here in person.
and Gavin, am I correct in understanding that regardless of your opinion or our opinion, the statute puts the county attorney responsible for that determination, end of story?
That's absolutely correct. That's the final analysis.
So we can all think that she was mistaken, but that wouldn't change the reality. It's all kind of moot.
Unless it goes before a judge.
And that wouldn't get us on the
Yeah,
this year's ballot
Yeah,
anyway.
we're done. I'm on this year's
Today is
ballot.
the last day that it's even remotely possible for me to put anything on the
We're
ballot.
sorry you bought all those ballots for nothing.
Well, luckily we can use them next year.
Good.
They got forever stamps on them?
They get ink jetted.
Pardon me, no.
No, we
We're okay.
can't open that can of worms.
You want to continue working backwards?
Yes.
Yes.
Yeah.
Fine with that. Is this discussion helpful?
Yes.
Absolutely. The county attorney's second point, we're again working backwards. We're still on page, we're on page
6.
6.
No,
Yes, 6 of the attorney's opinion. Just between us and the back fence, I think this one's flat wrong. However, the way I understand the county attorney's position on this is that in the section of the optional plan where we talk about prohibitions on the county council interfering with the executive branch behind the scenes or interfering under the table, we say, and this is on my page 2, the language that currently exists in the optional plan is this. It's section 212, subparagraph 5. Neither the council nor any member of thereof shall appoint, dismiss, or give directions to any employee of the executive branch or any of the officers of the county, nor influence or attempt to influence work assignments, individual personnel actions, or purchase of goods or services. So the county attorney's review reads into that the notion that we are being inconsistent, internally inconsistent with the council's ability to remove the county manager by a vote of the council. However, the next sentence in the existing language is this: nothing in this section shall be construed, however, to prohibit the council while in open or closed session from engaging in any of its responsibilities set out in this plan, or from fully and freely discussing with or suggesting or recommending to the county manager any other appointed elected officer or employee anything pertaining to county affairs or the interest of the county. So while the first sentence in section 5 says no interference, it seems to me it's fairly clear that the second sentence in section 5 says, however, when you're in an open meeting, you can do your council responsibilities, which would include voting. The removal of a county manager can only be by a vote in an open meeting. From removing the county manager. And of course, we do have other provisions in the draft optional plan that describe the process for removing the county manager by vote of the council.
Gavin, this seems like one item we could prevail in convincing county attorney that she went beyond her brief, because this is not in fact a reference to the Constitution nor to statute. It's a matter of internal consistency, which is not part of her review.
And that would be up to her as to whether
Right.
she...
But we might win that argument, is what I'm saying.
I'm not sure how far it would get us.
any other comments, Walt?
Unless the way it's being read is taken that we're saying that the council can't
Can't fire her.
can't fire him, and if that's the case, then we need to clarify that wording a little bit. We've said that they can be selected by 4 and fired by 3, which is pretty straightforward. But if the concern here is neither the council nor any member shall appoint, dismiss, or give any directions to any employee, that's meant to be those employees that are working for the non-elected officials that will be working for that executive, that county manager.
It also includes the other elected officials, sheriff.
Yeah, and them. So is there a clarification thing she's suggesting there that we ought to consider, or is it one that she just missed?
Chris, want to respond to that?
Oh, well, I just wanted to say there's two separate issues that she brings up. One is statutory. It has to do with the way, what the council can and can't do with regard to directing executive personnel. And I think she is saying that we went above and beyond what is allowed or stated specifically in statute. And so I guess maybe we should review that and make sure that the language that's in here is exactly the same language in statute, if we're going to include it, as has to do with that particular issue. And then there are two other issues that she brings up, which are a matter of internal consistency. One, I don't think that you picked up on, Gavin, which is the first part where it says neither the council nor any member thereof shall appoint. And we didn't give an exemption or an exception to the county manager. And so that's one issue. And then there's the other side of it, which is the removal of the county manager. And so we just need to make sure that in this section that, one, we're mirroring exactly statute, and two, that we make an exception for the county manager both for the appointment and removal.
And that was what I was talking about too. Maybe we missed some wording that makes
And I
that
think
not
we did
clear.
discuss that, and I just don't think it didn't end up in the final draft when we signed it. But we knew what we were doing as we went along, but it was just an oversight, I think. When it finally got drafted and everybody read it, just didn't pick up on that little blip.
Stephen, do you have a comment?
No, I think we can expressly detail that out. There's areas in the optional plan that laid that out line by line about the process. I think it is not ambiguous to that point. So I don't think we need to.
You see there, I've included a proposed change in my document based on what Chris has just mentioned. We could probably include or from appointing or removing the county manager using process described in the optional plan. Again, I think such a change is unimportant simply because of the exception that none of this applies, none of these prohibitions apply in an open meeting or in a properly convened meeting. But it's easy enough to fix, and whether it's right or wrong, we do need to go forward.
Yeah, fixing it doesn't change our intent, in fact.
No, of course not.
Right. Okay,
All right,
now to the
to the big one.
first issue that Ms.
Can I-
Sloan brings up.
Oh, the one that made us all see red.
Yeah, I didn't.
Of
course.
You didn't, Bob.
Maybe confused, but then maybe
Okay.
see red.
Let me make one last point, too, about the whole idea behind the separation of powers form of government. It's a little bit alien to us if we're used to either a county commission form of government or the existing Grand County form of government, where I think the elected council members, or I should say elected county commissioners, are really quite used to the notion that they get to direct employees in executive branch functions. If there's potholes out on such and such a road, the county commissioner will call up the road department and say, go fix those potholes. I don't know if that kind of attitude also prevails in Grand County. However, in a separation of powers form of government, and we discussed this quite a bit, and to some of us, I think it was a little bit uncomfortable, this notion that the county council can't talk to the manager. Well, there's a fairly significant impact to separation of powers, checks and balances, and one of those is communication between the legislative branch and the executive branch is all over the counter. It's not under the counter. It's not through the back door. It's all over the counter. So that's
Transparency.
it is transparency. I think that sometimes that concept's a little bit alien if you're not used to a separation of powers.
It used to be said in Grand County that the only people who would run for county commission were people whose streets were not yet paved. So it has been an issue here, in fact.
All right, the the main point, of course, the county attorney's review makes is the formation of the two council districts. And I know Christina feels extremely strongly about this. She may be willing to give way on the other 3 points, or one or two of the other 3 points. But this one she feels very strongly about. She's obviously done an extremely careful and complex analysis of the law, both constitutional law and statutes and some case law. I have to admit that as we were going through this process, I've had communication with her, including phone conversations. I kept trying to say, I don't understand what you mean by the notion that the existing county council, the pre-existing county council, gets to set the district boundaries, because I frankly never heard of such a thing. She asked me if I knew what the other counties that changed their form of government had done on this point. I sent her a list. I think there's been 8 change of form of government procedures go through, including both the ones for Grand County and both the ones for Morgan County back in '92 and then again currently. And every one of them except for Morgan County's current proposed optional plan, which is 5 county commissioners. Every single one of them has the districts created by the study committee and set out in the optional plan. So, with that as background, her point is basically, and I don't know how much detail you want to go through in reading both the Constitution, the statutes. I hope it's not an oversimplification to just simply say, number one, the Constitution says that the legislature gets to give out the power to create districts, which is true. It also says ultimate legislative power exists in the people. That's one of the discussions Christina and I had. I said, well, once it gets voted on the people, by the people, it's done. You've got that imprimatur that carries a ton of weight in the judicial system. But there are statutes that appear to limit the ability to create districts to county governing body, to create districts within a county. On her page 2, almost exactly in the middle of the page, the statute 1753-201 says a county legislative body may divide the county into precincts, districts, or other entities as permitted or required by law, and may change them and create others as convenience requires. So that's a legislative empowerment of the county governing body to create districts within the county. My response was, well, HB 224 is a legislative empowerment for the county study committee to do the same thing. The problem is, this may surprise you, HB 224 is not a model of clarity. And though it does state that the county, the study committee can create council districts as well as council at large, and then there's a general powers provision that says that the study committee can do and perform these other acts and other features in the optional plan to make it happen. She felt very strongly that is outside the authority of the study committee, that the best the study committee can do is make a recommendation to the current county council, the predecessor county council, to act before the election and create the districts as might be recommended by the study committee. Theoretically, that could include the county council coming up with its own districts, which would theoretically certainly be within their authority.
Question, Gavin?
One last point.
Okay.
Well, I'm sorry. The other concern I had is that HB 224 and its predecessor are very, very express on the notion that the current county government has nothing to do with the creation of an optional plan. And so to me, that's a fairly strong indication that the legislative intent, even though the legislature did not speak specifically, the legislative intent would probably be that the study committee makes that decision. I'm sorry, Walt, go ahead.
No, that's perfectly fine.
I would like to comment that had we went my way and had no districts, would be fine, wouldn't we?
So there.
Touche.
Now,
It's Bob's fault again.
that probably is true, but it wouldn't have passed. The
So there you go.
That was the whole point of this. is to
But,
find something
but,
solid.
yeah, that may be. But, we're okay with 3 at large and 2 districts.
Mhm.
It's the fact that we went ahead and drew the districts that's the issue here, am I right?
And one step further, we said these are the districts for purpose of the optional plan. So the redraft that I'm suggesting, the correction is that rather than the council or the committee say, these are the districts, we say, the committee says, we recommend to the county council that these be the districts. So that's
Okay.
the big difference.
So if we comply with what she's saying, we just take the appendix 1 or whatever off of the thing, our example of the 2 districts. We could, in fact, as you said, make a recommendation that those 2 districts, our recommendation is that they be a rural and an urban district, and they be based on the 2020 census. And would that be something that would be in our purview?
Yes, certainly. And there's my suggested wording, even goes further than that, Walt, in that it does preserve Exhibit A, but it
Okay.
adds this wording. The study committee recommends that the predecessor county council adopt 2 council districts as set out in this optional plan. The map of the initial council districts as recommended to the predecessor county council is attached to Exhibit A. That, again, as that comes back before the study committee, we can change that language however you wish.
Madam Chairperson.
Jeremy, yes?
Go ahead, Stephen.
And then Jeremy. Go ahead, Stephen.
My question is to Mr. Anderson, where in the statute then does it give us this back and forth of us going to the county council for them to demonstrate which districts they've approved and which districts they have drawn after the optional plan is created and voted on? So when the statute is absolutely silent to that provision, so when is that supposed to happen and what mechanism is supposed to happen?
I think that's another major concern. And again, it's kind of tied to the concern that the existing county governing body really doesn't have anything to do with the optional plan. You know, there's no outline of a process, a timetable for the predecessor county council to act. There's no provision for the county attorney reviewing the districts that come out of the county council. There's just no process for that. And to me, that's another good argument for why it's not only intended by the legislature, but it's probably just a darn good idea to have the study committee do it, because you do have those procedures, outlines, timeframes, fences about what the council can do and not do. Those don't carry through to the county council.
Well,
Just another
Sorry,
thing.
Jeremy's next.
It's okay.
then.
Oh, I'm
No,
sorry.
go ahead,
Go,
Walt.
Jeremy.
Go.
Sorry.
Well, I think one thing HB 224 is really clear on is that the current county government stays out of the process. I think that is absolutely one thing that is clear. To me, this is absolutely an insert of our current county government in this process. That's absolutely what it is. So for me, I look at it as, well, this is a violation of the law. For that to happen, we have to insert them into this process, which HB 224, in all of its ambiguity, in all of its contradictions, there is one absolute clarity, and that is the current sitting county government stay out of the process of forming the new government. So why is it happening?
Walt. And then Bob.
Well, I mean, Gavin, is there an answer?
I think Jeremy makes an excellent point, especially an excellent point in terms of public policy. But Christina, as I said, feels extremely strongly about this. She feels that the black letter law is on her side, as she spelled out in her if I were arguing in court about which position to take, I would put a great deal of emphasis on the notion that the current county government stays out of it. The current county council doesn't even get the authority to appoint the selection committee, let alone the study committee, let alone anything else to deal with former government. But that is her opinion. She feels fairly strongly about it.
Bob and then Walt again.
This kind of a distinction without a difference, really, because as I understand it, Christina argues that districting is a legislative function. I mean, that's basically her argument. And in fact, the state legislature has been quite clear that it intends to maintain their districting authority in spite of a statewide referendum to take some of that authority and give back to the people. And furthermore, what we need to remember is that no matter, even if Christina had not objected to this provision in the plan, the existing county council has the full authority to redistrict at any time, and the day after the plan were adopted could have redistricted in any way they wanted, as long as there were 3 at large and 2 by district. So the notion of taking the legislative body out of the process, while it might have some merit, I think is impossible given the county council's authority to redistrict.
Okay. Walt, did you have another comment?
I just think tied into this whole thing is a comment that is made by the county attorney related to the study committee as an advisory committee. And my understanding is the study committee is described in law as an entity with certain powers if the voters initiate that study committee. And then goes on to say recommend to the county legislative body and to the voters. No, we don't recommend to the county legislative body. We recommend to the voters. We are authorized by the voters, and we make our recommendation to the voters. At least that was my understanding of this. Now, we give a copy of this to the county clerk and to the county legislative body, but it's not for approval or anything. It's just it's a courtesy copy. What are we, an advisory committee, or are we a committee that has legislative authority if the voters activate us? And is there a difference?
Okay, just a moment.
I just really need to jump in. The voters did not activate this. That's what the lawsuit was about, the county one. And the county resolution is what started this.
Actually, the voters
HB 224
in the election
So the state
authorized the establishment of a study committee.
It went to ballot.
It went to ballot.
Yeah.
That's all I'm
Oh, I
talking
see.
about.
I see. Okay, went to ballot. Jeremy?
So and correct me if I'm wrong, Gavin, but we're an arm right now, not of the county, but of the state. We have been appointed based upon our state legislators. Correct, Walt? I mean, you were there with me. This is the state legislators who empowered us with these powers. This is not the county empowering us. This is the fundamental argument where we get into what is a county. What is the workings of a county? It is the functioning arm of the state in our area. That is what it is. And that's what we're representing here, not the current council. The current council that by all means is mute. Period. This council, this government changes regardless of what we propose. If it is voted down, it changes to a 3-member commission all at large.
If we do nothing.
If we do nothing, absolutely. Or if it's voted down by the people, whatever plan we choose. Therefore, we are being empowered by the state legislature
To form.
to form this government. And I think when I read this felt, and I'm going to call it like I see it, this felt like, hey, we're going to take control and we're going to decide what the districts are, no matter what consensus was formed and no matter what powers you were given, we want the control on that, even though we're not going to be around for much longer. And to me, it feels like a power grab. absolutely what it is, and I want to get that on record. I feel like it's a power grab. I feel like it's a play. Now, I know there's nothing we can do about getting it on this ballot, but I will be danged if I allow the sitting government of this county to put their fingers in this pie and in this process when there is one clarity in HB 224, and that is to stay out of it. Everything else is fixable. But this is wrong. This is gerrymandering.
Should I respond to that or Bob first?
Why don't you respond, Gavin?
All right,
and
very
then Bob.
quickly. Christina, to her immense credit, did send both to Chris and I initial draft of her opinion asking for, initial review from us. And for what it's worth, she originally had 8 problems she saw with the optional plan. That came down to, of course, to 4. But one of the responses I made in her draft, she really emphasized and overemphasized the notion that the study committee is an advisory body. I responded that it's a government entity. It's created by state statute. It has very, very significant powers. It's an entity of very limited shelf life, but it is nonetheless a government entity that the legislature has vested with significant legislative authority to essentially be founders, framers of the Constitution of the new county form of government. So I do think it's incorrect to suggest that the steering or the study committee is an advisory body, especially after it goes to election and the voters adopt an optional plan.
I believe I was next.
Bob, and then
Thank you.
Chris.
Again, I think this is a distinction without a difference because the HB 224 does not, in fact, remove any authority from the county legislative body. Their ability to redistrict remains untouched by HB 224. Even if we were able to call out the districts, they retain their legislative ability to redistrict. Furthermore, honest people can disagree here, and I do want to point out that my colleague from the Republican Party's legal opinion has not been supported by the courts on a matter relating to the study committee previously. I'm not a judge. I can't tell who's right or wrong here, but I think, as Gavin has pointed out, lawyers do disagree on matters of law. That's why we have courts. In this case, the county attorney is vested with the authority to make a determination, not to offer an opinion, but to make, she's cutting the baby in half. Whether we agree or disagree, we have to live with that. Now, we will have an opportunity to try and dissuade her from parts of her report that we think are in error. And I would suggest that we try to do that if indeed we feel that way.
Chris?
Yeah, so as Gavin mentioned, I did have a chance to see this last week, and I have to say that I totally disagree with her opinion on this, the council districting issue. I think that the legislation has given the power to the study committee to draft all necessary implementing provisions, and that's obviously one of them. You can't say we're going to have districted elected officials without the district that goes with it. The law that she calls out says that the legislative body may redistrict. What happens if this passes and they just don't do it? How do I run an election?
Good question. I have to say
so,
that I agree with you on
Can
this,
I finish,
Chris.
Bob?
Yeah.
And so, I don't agree, but sometimes in politics you're playing a game of chess and you've got to deal with the fact that your opponent's got power and they can do what they want. And in this case, I feel a little bit of antagony with the county attorney over this one, but it may be all for nothing. Maybe we say we recommend to the current sitting council to adopt this district, and they just do it, and it's fine. We don't know if it's going to be a big issue or not. But I would say that I do believe that the legislature in the drafting of HB 224 has empowered this body to draft the districts in the plan as a necessary component of enacting the plan, and it obviously is. And you have to we all have to be clear that nothing that this committee does takes effect unless the voters vote to approve it. And so it's the voters really who are enacting the district, not this committee. And so, and it is possible to pass legislation by ballot initiative. That happens. And so I'm just saying, I think that maybe we could argue this point, or maybe it's not a big deal and we can just rewrite it to recommend to the council to pass these particular districts, and they'll just go ahead and do it and it'll be fine. But maybe they don't. Maybe they change it. But they don't have to change it to be anything in particular, and that's the problem. We need a very particular arrangement of districts. We need 2 of them. We can't have 5 anymore. And if they fail to do anything, then we can't even run an election. There's got to be some. It's necessary that these districts be established, and the only mechanism that I can really see for that to make sure that that happens is that it's contained in the optional plan and it's approved by the voters, and that's the only way to guarantee that it happens.
Okay,
Marcy,
I'd like to
you're
make a
next.
comment, and then
Because you
Bob,
had your hand
and
up
then
the
we
longest.
have a person in the audience that would like to speak. First of all, this committee spent a lot of time learning about districting and looking at the numbers in this county, and I feel like our recommendation for the districts was extremely well thought out and carefully made. My question is this: if we want to stand by inserting specific districts into this document, what if we cannot come to some kind of agreement with the county attorney on this issue? Does she then
And we get
derail the
3.
whole process forever?
We get 3 commissioners because we can't decide.
That's my question to Gavin.
So let's
If she can't approve our optional plan,
We get 3.
I feel like now
second
we're
option.
being held hostage.
It's litigation.
Absolutely.
I feel like we're being held hostage.
Who's going to live?
We have a drop dead date of the November election in 2020. If
Wait,
Hey, guys.
You guys, Gavin's speaking.
if by the end of the year of 2020, Grand County has not adopted a new plan of government, that's the point at which it goes to a 3-member county commission. That form of government probably doesn't require an optional plan because it's a standardized form of government. So if it doesn't happen this November, which it's literally not going to happen this November, then something has to happen in November of 2020, and that's going to require an agreement between the county attorney and the study committee that she's going to agree with whatever changes that the study committee makes in the new amended optional plan.
Bob and then Judy.
Yeah, I agree with Chris's analysis here, I have to say. I think that the legislature clearly envisioned the study committee recommending all the details necessary for the implementation of the plan, including the actual boundaries of the district. However, it is also clear that the study committee envisioned the county attorney having an absolute say as to whether or not the proposed plan is consistent with the state constitution and statute. So while we may believe that the county attorney is fallible, I just saw a movie in Telluride called The Two Popes, and one of the things I really enjoyed was being infallible. Sadly, the county attorney doesn't have that. This may be something we just need to give way on. I I believe that, again, it's a distinction without a difference, because no matter what the optional plan says, if it were adopted with the districts that we call out, the county council, the predecessor council, I think clearly has the authority to redistrict at any time. And again, the legislature's been real clear that they want the legislative bodies to maintain that authority in spite of what voters might say. I think that we have enough authority to push the predecessor council to adopt the districts that we propose, mostly because we did a lot of work, and they're, if you're going to have just 2 districts, I think we came up with a fabulously good solution. And I don't think there's another way to do it that's anywhere nearly as good. So I'm quite confident that we can prevail even with a recommendation here. So I'm not all that concerned.
Okay, so did you still want to speak? Then Judy, then Jeremy. State your name, please, for the record.
This is Charlotte Mates. I am a citizen of Grand County for 20 plus years. Again, in all due respect to the whole process and to the whole legislative and judicial and the entire process of keeping this America with a democracy and with the efforts that have gone into this, and again, as we stated prior to this, one of the things I'm sensing is that we could debate this until the cows came home. This needs to happen this year. There are almost 3.5 hours, and I am willing to put my name, my reputation, and any future reputation I have on the line and sue whoever I have to get this on the ballot for 2019. I believe that strongly in what's going on. I do need some direction. Perhaps Gavin or Stephen can give that direction as to how I would go about that process and what that would take. But I do not believe in having people who have struggled, met together on their own time for the benefits of this county and for our state and for our American democracy to be jeopardized by the actions of, as Judy said, much ado about nothing. And Gavin, I'm going to point this to you and ask you for direction in how I could go about doing that.
That might be an item that you guys could talk about
After.
Okay. We meet.
If I
appreciate your support.
If I have to be, this lawsuit has to be in by the deadline of 5 o'clock today. I want it on record that I have stated this, and I want that on the 2019 ballot, whatever that takes.
Thank you for your comments.
Thank you. And I hope that I have not gone outside the law of this meeting. Thank you very much.
Okay, we're going to have Judy, and then Jeremy, then Walt.
Okay, so if this goes to the 2020 election, we don't make it, we can't, Christina won't approve what we present. Do we go to a 3-man commission on January the 6th of 2021?
Yes, you would. Sometime between now and March 8th of 2020, this committee has to agree with the county attorney as to what an amended optional plan is going to look like. My concern is that there is no process in place for making that happen and making it happen timely. So there is a possibility that there might be an impasse. I would hope not. Reasonable minds can always agree.
This is Grand County. I don't think so.
But that's a distinct possibility.
Jeremy?
I think the reality of it is where we really differ is on the function of this body. I think what Christina sees is us as in this advisory role where we've been initiated by the county, and that's what it is. But I see it completely different. I see that this has been enacted by legislation at the state. The reason we fall into this category is due to the inconsistencies and legalities that fall into our current form of government, making us illegal. And we have no choice. And if it wasn't us sitting on here, it would be somebody else sitting on here being empowered with the same powers that HB 224 has. I will reiterate, the legislative body made one thing in the bill clear, and that is that the current process is to be hands-off except for appointed times. And yes, Christina has an appointed time in which she is to review and make sure it's constitutional and that it follows the law. But the reality of that is, if that county attorney is infallible and she makes a mistake, there are recourses, and I would hope the first thing we can do is discuss. But there are other recourses too, and that is a judgment. That is to go before a judge and have it clearly defined. And I hope it doesn't come down to that. But the reality of it is if our county council wants to stick their fingers into it to maintain power and maintain control, I have a fundamental problem with that, because it is a violation of the law. What we're not thinking of is if we violate that law, and that county does that, all of our hard work could go down the drain because of litigation from outside influences and saying, you broke the law. All of the work that we've done could be undone by a third party through litigation. And they would have a valid point to do it. Now, having been down this path with the county, it's not fun. It's not pleasant to go through that lawsuit. I hope once we get Christina here that we can go through this. And as much as I would love to see this on the ballot now, I see that we are in beyond the 11th hour. The clock kicks beyond. We would need one of her representatives here empowered to be able to go through it with her and to be empowered to agree and to do it. And we don't have that.
No, we can't do it
We
anyway.
can't do it anyway.
So it's 120-day limit on
So
changes.
we're by law, by statute, unfortunately. And this is a big unfortunate because I know how hard this committee worked. And I know how much was done in the 11th hour, that we got it in. And it breaks my heart that I feel like politics are being played in a process where no politics have been played. And I can say that with every fiber of my being. Me and Bob may disagree fundamentally, but we found concession throughout this process.
Me too.
You know?
Where's Get the Religion? And we agreed a lot.
We did.
A lot, did we not?
And we did. And I have had members of the community come up to us and say, through this process, thank you for not making it political.
Yes.
And yet here we are, and I feel like it's being made political.
Okay, Walt?
Yeah, just
and
a
we're
just a
gonna
couple
try
of
and wrap
things.
this up.
Ms.
Stephen,
May,
if you have a comment.
Ms. May, there's no way anything we can do today is going to get this on the 2019 ballot. It's a done deal. It's way past the 12th hour. I mean, I'm not even sure what a lawsuit would do other than spend a bunch of money for no good reason. I am not going to be very supportive of lawsuit business. And you answered my question really well, I think, Gavin. We're not an advisory body. We have a clear legislative responsibility, and we've exercised that well. I would hope that we can move now to sit down with her. I would hope that we can get some more information with you, maybe to use in discussing, not arguing, this districting authority that we think we have. If there's a way to clarify that for the purpose of sitting down and discussing. The other thing, Jeremy, and I'm not sure exactly what you're talking about, that I don't want to throw around too much yet, is I haven't gotten anything that I know of personally where the existing county council has stepped into this process. And I think before we accuse that, we should have specific examples of that we can talk about maybe together. But nobody that I know of has inserted themselves into this process. I have no idea what's going on behind the scenes, who's talking to you from the county council or who's talking to Bob from the county council, but nobody has talked to me about saying we have a right or a expectation that you're going to coordinate with us. I don't know of any example, and I hate innuendo and suggesting things that we don't know are true from anybody, and I won't be a party to it. And so I think we need to be straightforward and move down this road in a way that we sit down with the county attorney next and we talk these things through. But I would really like to have some more legal ammunition to discuss this districting thing and our authority to do what we did with the computerized, generated, census-based, completely unbiased districts that we put together. And I think that's all I have.
Just a second, Stephen. First we'll hear from Cricket and then you.
So I find it interesting that the legislative powers that we're talking about, Bob keeps talking about, is that they have at any time that they can redistrict. So I don't understand why there's a problem that this get passed with the districts we fairly, and we're very careful to make sure that nothing looked gerrymandering. We had where there were no voters, we had to make it yellow or blue so that there was no confusion, that there were no weird lines. I mean, we spent, what, 2 hours looking at maps, trying to make it clear. So I don't understand the threat that they feel, that she feels that they need to have that authority, because once it passes, they get to change it anyway. After they're elected, if they don't like it, they can change it. So I don't understand. I personally feel like, let's figure out how we can stop this from getting on the ballot. Because we had Mary stand right here and say, you know what? I was elected, let me finish out my term. And I feel like they want to finish out their term because their pay is going to go way down, and that's my opinion.
Stephen?
So here's my thought, and this might help us move in the advancing. Gavin Emerson has mentioned that he was talking to students, especially late, public discussions about this. That being said, he's discussed with her, his legal position, she's discussing with him, her legal position, and there has been essentially no shift or change. So I have not ever asked to do this before, but I think at this point, I'd like to discuss frankly with our attorney in a closed session about what our options are moving forward. Because if we're at a impasse, we're essentially either we have to say yes to this alone, and every change that she makes, inevitably, if there's any suggestion she would like. So I think at this point, I would make, and I'll probably make it to this, I'd make a motion that have a closed session based on the possibility of submitting for imminent litigation. That way we can follow and make more progress if we're in
Stephen has made a motion to go into closed session to discuss the possibility of
I'll second the motion.
litigation. Jeremy has
The law
seconded.
does not allow
Yeah.
closed session for the possibility of litigation.
Here's
It
what it-
requires reasonably imminent litigation, and I don't think we've
Well, let's-
reached
I think
that
there is
threshold,
reasonable litigation.
because in fact, possibility doesn't rise to the
Ruth
level of
would
the
like
law.
to say something.
Well, just that, I think what Mr. Greenberg is saying is correct. The state law, Open Meeting Act is very clear. Closed recorded sessions would be regarding discussing pending or reasonably imminent litigation. And so if you think that this is reasonably imminent, then you could go into closed session. It takes a vote of at least 5 of you.
Okay. We have a motion on the floor. It's been seconded.
Sorry, who seconded?
I did.
Jeremy seconded, Stephen made the motion. Discussion on the motion, I would like to make a comment. I feel like this committee has conducted itself with the highest behavior, that I've seen in a potentially politically explosive situation, that we have really worked hard to listen carefully to one another and, tried to reach consensus. And I don't think that we should be changing that course of action just yet. I feel that we need a chance to sit down with the county attorney face to face, give her the same consideration that we have given each other, and try to move forward in that kind of a reasonable fashion. And if that fails, perhaps we look at some other alternatives. My concern about, and this is maybe not applicable to the motion, but clearly we have a sense of urgency about what's going on with this plan and being able to get it lined out and everything where it needs to be by the time the end of our tenure. I do not feel, and I have not felt from the county attorney, that she has the same sense of urgency about our charge and about moving this forward, and I would suggest that that's the first thing we need to come to agreement on. Judy, then Bob?
I see no harm in going into a private discussion with an attorney for this group of people and finding out what Gavin thinks we should do forward. I don't think that's against anybody. I just think it would be an opportunity to be candid about what the process needs to be, whether we can, all of us can make the changes that she's recommending, and give her that. I see no harm in going into a closed session myself.
I agree with you, Marcy. We're jumping the gun here. I think if we're not able to persuade the county attorney that our interpretation is the correct one regarding districting, I think there are a number of other potential political solutions that we ought to be looking at. I'm a little concerned that we accord elected officials the same courtesy that we have accorded each other, which is not to impugn anyone's motives here. And I would just ask that you all join me in really trying to be careful with that. There's no evidence whatsoever that the county council is attempting to meddle here. I've certainly never gotten any communication from a council member concerning the study process other than a thank you from several of them. And I don't think any of the rest of us have either. Again, I think we're jumping the gun. Let's see where we can get to with a meeting with the county attorney. And then we can, if we don't like the outcome of that, then we can explore other options. But I just don't think it's time to talk about litigation, even if it were possible, which I don't believe it is.
I certainly concur with Marcy. This isn't the time for us, as they say in Texas, for us to come from together, and we need to stay steady into this thing. I also think you need to be real sure before you take this vote, because I came in and told Ruth I think we're going to need to have a closed session so we can talk to our attorney, and she assured me you cannot legally do that. And I'm not going to vote for something that we can't legally do. It makes no damn sense whatsoever. So I'd like to know from Gavin and Ruth and Chris or whoever before we take this vote, which I'd rather personally sit down with Christina, again, having more information from Gavin and who else about what are the legal basis for making an argument that we, the study committee, a non-advisory committee, but a mandated committee, a legislatively authorized committee, and a voter-approved committee, what powers we have, that if she's hanging her hat on the fact that we're purely an advisory committee, that may be a point we can dissuade her of legally, and that we have that authority. I'd like to try all that first before we sit down and talk about anything else. We're premature with going to that, and since we cannot sit down and talk to Gavin, since we can't close the door and talk to Gavin because we do not meet one of the criteria in the law, unless I'm wrong with what I'm saying here, it's premature to do that vote.
Mr. Stocks?
Here's what everyone is assuming that we are going to be able to convince this a little bit. Gavin Anderson, our attorney, has talked about this. He's been the one that has had these communications with her. I'm simply asking for the ability to communicate with the attorney about this and close that. I don't know how else to express. She's had the opportunity to discuss this with Mr. Anderson a number of times, and that is still the conclusion that she has. She's explained it to us in writing. And on the receipts that we have 4 receipts, 3 of which don't alone merit much. They, according to the attorney, he said that they could be there, but they're not. Constitution guard. The problem with our existence as a board is we have a very finite period of time. I think moving into options to be able to look at this is important. Gavin Anderson is currently there. You guys have the opportunity to talk to them and be frank and ask frank questions. That is very, very important. Push this off another 2, 3, 4 weeks. By the time that we get anything, who knows if we'll have the time to get back before March. So that is the only reason why I'm important. I'm not saying that we jump to conclusions with anything. I'm talking about having a frank discussion with the attorney. Having a full session is not closing the door on each and all 3 of the possibilities whatsoever, but it could be the ability to resolve pending litigation through a conversation with our attorney as to how we can settle it. I'm not saying we're going to draft up documents to initiate a lawsuit. I'm saying we can look at how to resolve it. And another point that is important is I think it's really critical and important to understand when our attorney is communicating with Mr. Maloney, because we haven't been privy to every conversation that they've had. So that is my request. I'm not saying throw out courtesy. I'm not saying throw out chivalry, nothing like that. I'm saying have an opportunity to talk to the attorney in a private meeting like any other person or individual would have that same respect, have their attorney, have a friend discussion with them. So I think a lot of you are mistaking what I'm saying by taking this opportunity to talk to him. And that's why talking to our own attorney first, privately, about this is critical, because otherwise we're going to go sit down with Christina and not fully understand all of the options and abilities that we have to resolve it. So I think that's why this isn't jumping the gun. This is preparing for litigation if it is, or preparing for the settlement to resolve potential litigation if it is. And that's why I do want to make that point that you guys don't vote for that. I just want you guys to understand my position and not take in front of this board, but as we have the client that I would have. Normally, a client has that ability to have that time with their attorney. So that's why.
Thank you, Stephen. And then we have Bob, and then Gavin, and I have a comment.
I'm just, we've bent over backwards by consensus, by unanimous consensus, excuse me, to keep this process as open and public as has been humanly possible. We've conducted more public meetings than I certainly can remember have been conducted on any issue in the last 40 plus years. Let's not stop now. I don't know what you all think you want to say or ask that you couldn't say or ask in public. But
I'm down
Let's
with
have
that.
it now.
yeah,
Let's get it out.
Okay.
let's get it out.
Gavin's
I agree.
next, then me.
Just trying to save face for Christine. There's still a motion, right?
Still discussing.
I'm sitting here trying to think what my exact legal responsibilities, attorney-client relationship is with the committee. I think our contract between Grand County, Salt Lake County has it that I will help draft optional plan of government. I'm not completely comfortable with the idea of giving you advice on either litigation or whether you could close the meeting under the Open Meetings Act. I think you'd have to ask yourself in terms of the litigation exception, can you honestly say to yourself litigation is reasonably imminent? I should not go any further than that, other than I will do what the committee asks of me within my attorney-client responsibilities.
So one of my questions to you, Mr. Anderson, is where can this committee turn in terms of expertise and interpretation of the law with someone who has experience or an opinion on A, our authority, and B, this concept of districting? That would be a question. And then I will just maybe address the elephant in the room. And I can say in honesty, at one point very early in the process, County Attorney Sloan said to me that she did not believe that a county manager form of government was appropriate for Grand County, and that she disagreed with that. I think that in and of itself creates some bias. I do believe she's very thorough and professional, and I think that she has gone through our optional plan with a fine-tooth comb, and I think she has done her homework in terms of evaluating state statute and rules as they apply to our plan. And I am grateful that we have a county attorney that is so dedicated and professional, and I'm grateful that we have a county attorney in that position doing that job. I think that I said in a public meeting when we presented our optional plan to the county council that at one point in time I was absolutely shocked to consider that there may or may not be individuals or groups in our community that wouldn't want this to go forward in a timely fashion. I was so surprised by that. And yet, I think that that could be the case. And for me personally, I have just let things unfold and have not had any contact with the county attorney one way or the other during her evaluation of our plan. I hope that Mr. Anderson is the only one that she has talked to and our clerk, but we don't know that. So I think those are the questions and the innuendos that start to go through people's minds, and I don't want to operate on those faulty or assumptions. I want to have a face-to-face conversation about these very issues. Walt and then Chris.
I think also, if my old brain is not fuzzy on this, she didn't even have the full amount of prescribed time to review this that the law gives her, and so the fact that we got that yesterday was because she was willing to spend the time, and my impression is from other people that she didn't even make the last county council meeting because she was working on that thing. So I really agree with Marcy. We need to sit down and talk with her face to face and talk these things through. And again, I would request, Gavin, from you, not opinions, but yeah, I always want your opinion, but specific rebuttal or discussion pieces that we can use to substantiate that we, with some pretty serious authority in this study committee, were supposed to do what we did. Now, we got a couple of little technical things wrong. I appreciate that, but I still do not believe we got this districting wrong. And
so
that's it.
I didn't mean to cut you off, Walt. So Chris, and then we have a motion on the floor. I think we should.
The last thing I'd say is before we do this vote, I would very much ask Ruth to read the specific things we can have a closed session for. You all ought to know this before you vote for something that we can't legally do, and be sure of it. As good as it might feel to vote for that thing, I was coming in because I wanted to do just what you said, Judy, and close the door with Gavin, who I understand also is hesitant because of his professional position, to take exception to another person with in a different county openly. I understand professional courtesy. I was a law enforcement officer. You don't do that to each other very well. So thank you. And again, I would ask that Ruth read that list before we vote.
Chris?
I don't know if this committee is considered a political subdivision of the state of Utah, but most political subdivisions of the state of Utah, if they're empowered to sue and be sued, they state that specifically. The state code doesn't say anything about this committee having the power to sue. And so I would be wary, certainly, of assuming that. Obviously, any individual can bring a lawsuit, but as a committee, whether you'd have the power to sue, that's not explicit in code, and it is in general for most political subdivisions. It's spelled out specifically. My interpretation of this particular issue would be that you can go into closed sessions to discuss bringing a lawsuit. But you can't go into closed session just to get general advice from your attorney, and that's different from a private individual, obviously. But government's restricted by state code in terms of what they can and can't go into closed session for. And so I would say that it's pretty questionable whether you could go into closed session, partly because you don't know if you can even bring a lawsuit as a committee. And two, has it really gotten to that point where you're ready to imminently bring a lawsuit? I mean, imminent means that you're going to do it. Like you're right on the cusp of bringing a lawsuit. Are you at that point? And so, in my opinion, there's a lot more discussion that could happen outside of that particular conversation.
I have a challenge for Jeremy here. See, I think we could deliver a political solution pretty easily by going to members of the county council and asking them to pass a resolution stating that they will follow our recommendation on districting. We could moot the whole thing here. And I think between you and Kevin, who I see in the audience, and me, we probably have enough clout, credibility, access to ask that at least be brought to a vote, and I bet it would pass. Because again, I think we did a great job. I didn't like 2 and 3, but having gotten there, I think we did the best you could possibly do with that scenario, and I don't see any other viable way to slice it up. So I think there's a simple political solution here that kind of moots the issue, and we ought to go for it.
I think it has merit.
Okay. So, Stephen, do you want to keep your motion on the floor? Do you have any desire to change or amend it?
And here's one other comment in response to Bob. What we're doing is we're giving the county council authority to do that. We're giving the county attorney. I stand by my motion. I think it's important to understand that there's reasons why other individuals do not want to, but I stand by the motion. I would ask for some also.
Okay. Okay, so we have a motion on the floor to go into closed session to discuss with our attorney, Gavin Anderson, for, I suppose, reasonable or
Pending or
Let's have
reasonably
Ruth-
imminent litigation is the motion. And there was a request also that I read other options.
what are our options?
Acquisition of real property,
But
security.
you are stating a motion.
That's
She's got a list.
Oh. I'm lost. Okay, so I would assume that the reason that we are going into closed session would be pending imminent litigation. Reasonably imminent litigation. It's been seconded. All those in favor,
So
please.
before you vote, did you want me to read the whole
Yeah,
list or not?
will you read all of them?
Thank
Walt
you.
has
Is
requested
that your
that.
request? Okay.
Yes.
So there's like 7. Collective bargaining issues, pending or reasonably imminent litigation. These are recorded. Purchase, exchange, lease, or sale of real property, including any form of a water right or water shares. investigative proceedings regarding allegations of criminal misconduct, commercial information obtained from a property taxpayer. The ones that are unrecorded are deployment of security personnel, devices, or systems, or character, professional competence, or physical or mental health of an individual.
Okay. I will call for the vote. Those in favor, please raise your hand.
Aye.
Those opposed? Those abstaining? Okay. So the motion fails 5-1 with one abstention. Is the abstention a no vote essentially? Okay.
So failed 1 to 5.
Yes, failed 1 to 5. Okay. I think we have exhausted our conversation about Attorney Sloan's letter and Mr. Anderson's advice.
Can I make one more point?
Yes.
I don't want to leave anyone with the impression that I'm not willing and anxious to go forward with putting an optional plan together that's agreeable to the county attorney. I do think that's part of my professional and contractual obligations, and so I intend fully, to the extent the committee wants me to help, to work with the committee and with the county attorney to put together an optional plan that will pass or muster.
The only thing I was
Jeremy, Bob?
gonna ask that if Gavin had any closing observations or anything to share with us on this thing, and the other thing to say, absolutely, that when we sit down with the county attorney and we're gonna talk through these items, we need Gavin here. It needs to be a meeting that has Gavin sitting right there with us, and I think it absolutely, a full public thing would be fascinating for everybody to listen to. Everybody have to explain how they got to where they're seeing it from, and I think that would be a very interesting day. I don't want to miss that one.
Okay, Jeremy?
Real quick, I would like to, I don't know if it needs to be a motion, but I would like to make it so that Ruth could coordinate that sooner rather than later with Ms. Sloan, with Gavin, with us, as when we can meet and we can discuss this.
Yep.
I would like that sooner rather than later, and if we can coordinate that and come up with a scheduling time, that's going to be sorted out. And I have a feeling that this is going to probably be more than one meeting, and we need to be prepared for that. Because I know Christina's time is finite. She's busy. I know Mr. Anderson's time is finite and busy, and obviously, according to that, we're willing to be here all night if we have to get it done, but I don't think they're going to be at that point. But in that being said, I'd like to empower Ruth. I don't know if we need a motion to do that, to make that and coordinate that, even if that requires us to call a special meeting.
Here, here.
So moved.
And I will reiterate what Bob said. If that is an option, Bob, and we need to do it, and they pass a resolution, that's okay. I'm just saying that this is a possibility. But I will I will stand on my stance that I think it is overreach, and I think it's fundamentally wrong according to the law.
Yes.
And I think if that happens, there are people out there who, like Marcy said, it surprises her. It doesn't surprise me because I've gotten hate mail over it. That they want this to fail. There's a faction of this community that want a 3-member commission and would love to see nothing more than this fail. Period. And they'll do that by any means necessary. And it exists. It's an unfortunate thing, but it exists. And I don't want to see that happen, because if there's one thing I'm proud of our community. As odd as we can be, as different as we are, and we come together, and this proves it. And I think with the current politics that we see in our country, that Grand County, of all the counties in Utah, can come together and find concession gives me hope for our future. And I just don't want to see that get muddled through any lawsuit, and that includes us. But the reality of it is we are where we're at. And I would love to see Ruth be able to coordinate that, get back to us. If we need to have a special meeting, we have a special meeting, and we do what we got to do to get it done.
Here, here.
I think we can just ask Ruth
Yes.
Yeah.
to do that, and obviously first choice would be one of our existing scheduled meetings, but
So, on this note, we have heard from our county attorney, and she cannot be available on a scheduled meeting until the 27th of September at the earliest. She's willing to do any special meeting, preferring a Tuesday. Fridays are not the best for her, preferring a Tuesday. Right now, she's dealing with something very important with her family, so.
Absolutely.
right.
So we've got to give that time, obviously.
Absolutely.
Right.
We agree. I would just like to say that, people have asked me a lot. I've been to ask in the recorder's office, I've been asking in the store, and I said, I'm very proud of what we did. We worked hard. We went line by line through our Constitution. We tried really hard to think of unintended consequences. And I'm excited and really look forward to getting onto the election. Now, when I read the law, when I got chosen for the committee, how I read it and why I pushed for it to be on the ballot is if it isn't, then it can go to the 3-man. And that's my fear. And another thing is the legislature could look at what we're doing and, hey, we didn't get it done, so we're just going to make you. They could pass a law this year, and we might just end up with the 3-man commission. I myself would have rather have what we have here. And I'm worried. I'm telling you right now, that's why I wanted it, because I want some say in our government. And we're all hoping that everybody will agree and vote thumbs up on what we worked so hard on, that we actually agreed on. Well, I know that. And we could very easily be voted down. Very easily, just as easily as we could be voted up, right? But that could possibly not even happen. And that just disappoints me.
Gavin, do you know if you're available the 27th?
Almost certainly. I can adjust my schedule.
If Christina is, and you guys know your schedule, we ought to go for that.
What do you think about also, you'd have to make this decision, I have no input, open a discussion with the county council and just see what they would be inclined to do in terms of setting up the council district.
Well, do we do that formally, or do we do?
I think we do it. Getting the cart before the horse a little bit.
Probably need to talk to Christina first.
I think we talk to Christina first.
I
We
agree.
see where she stands, and we see if she's going to give us any wiggle room. Maybe some more time on her plate. Maybe the court of public opinion, and a little pressure goes a long ways. I don't see this playing out very well with the community. I've already been told that when asked if this is going to be on the ballot or not this year, and I said, well, it all depends on our county attorney, whether, there is some strong sentiment out there. And they might not be coming to our noon meeting, but I've heard from them. And so I think I hope it works itself out and we can find concession as we have continued to find concession through this committee with our county attorney.
I'm hopeful here. I spoke to Christina last week, just asking her if she thought she'd be done. She said, well, I'm going to try, but I'm not a constitutional attorney. I wish I had some more time. So maybe with Gavin's continued urging and more time for her to research it, she might come to a different conclusion. But I think 27th would be great.
I don't feel much like an expert anymore. I am the only attorney in the state who has had an optional plan rejected as unlawful.
Can I say something? You know what? I think
this is not rejected.
This is.
I think that really
Welcome to Grand
speaks
County.
to the thoroughness of our county attorney, which, she's doing the job for the citizens of Grand County. Secondly, I think that our optional plan is by far and away the most comprehensive, flushed out, thoughtful optional plan of any that exist in the state right now. And that is due in part, mostly,
Well,
to your
yeah,
credit.
Here, here.
You're very kind. I do know that in other counties, the county attorney has taken little to no interest in this kind of an activity. You're well served by Ms. Little.
Move we adjourn.
Wait.
One quick comment. It's perfectly okay, I think, with this group if behind the scenes you and Christina talk through this stuff before we get to the 27th.
I'm sure we will. I need to send her this attachment G and make sure she's aware of that. I didn't want to give it to her before you'd see it.
You might
Okay.
ask Stephen if he has any final before we.
Stephen, do you have any other comments before we have no public hearing, no future considerations?
Well, I have a future consideration.
Uh-oh, Ruth has a future consideration. Stephen, do you have anything
That
else
too.
to say today?
But I'll save it for a different day.
Okay.
Thank you, Stephen.
So
Ruth?
just the future consideration is, you're not scheduled to meet next Friday, but you are the 20th. Is there any reason to meet on the 20th?
No.
So I will have to formally cancel that. I will do that. And so that's the first meeting you'll have canceled.
27th.
And
And so can I put on the 27th agenda
I've already got mine on my calendar.
that we're going to have this open public discussion with our county attorney and your attorney here? Okay.
Please.
and then we'll decide how to move forward after that. All right, Bob has made a motion to adjourn. Do we have
Second.
a second? Jeremy seconds it.
And what time
Get
is
them
it?
in.
It
Thanks.
is
No.
2:19.
I just want to recognize the fact that we had a hell of a chairman today.
Yeah, yeah,
Well,
good job.
yeah,
Good job,
that's
Marcy.
that. Okay, all those in favor of adjourning?
You.
Aye.
Aye.
Good job. Everybody have a homemade cookie. They're
Yes.
soothing. Come on, Carter. I know you're not off the sugar. Jeremy, you are.
Yes,
And
ma'am.
me too. I haven't had any sugar. I haven't had any sugar in.
Oh, let me stop the recording.
You look good, buddy.
Don't you feel better?
This is a
Yes.
month? I thought he was gonna say 4 days.
No, 4 weeks. 4 weeks.
Seriously. It's sore, but it's good. I mean, they went in and
How are you doing?
vertebrae, they
You
move
have a good
everything.
time?